ओके। गुड मॉर्निंग माय सुपर हीरोज। हाउ आर यू? कैसे हैं सब लोग? कैसी चल रही है पढ़ाई? होपफुली you all of you have got revision of the last lecture. So let's start with the day. But information है from the side of ICAI that any query from your side, please student listen carefully. Any query from your side, please send on the portal, not on this chat box. ठीक है? Due to some technical problem, so there could be no chat on this Zoom portal. So please send on the ICAI portal. जो query है आपकी वहां भेजिए, right? So let's start the good morning everyone. So let's discuss the section number 11, 12, 13, 14, 15 and 16. But I am discussing here only the first part of the chapter number unit number 3, right? Minor means person who is under the age of 18 as per the section 3 of Indian Majority Act 1875. Legal rules regarding the agreement with minor: it is void ab initio from very beginning, cannot be ratified on attaining majority. On attaining majority, it means it cannot be ratified even after, it cannot be confirmed even after get measure, cannot be asked to compensate or pay for any benefit under a void agreement. अगर कोई बेनिफिट लिया है उसको पे करने के लिए, कॉम्पनसेट करने के लिए भी नहीं कहा जा सकता. माइनर कैन ऑलवेज मिसरिप्रेजेंट हिज माइनॉरिटी. Minor cannot enter into partnership as per the Indian Contract Act, but Partnership Act specifically provides if all the partners are ready, then a minor can be a partner for benefits only. As minor has no liability, so he cannot be adjusted as insolvent. Parents and guardians are not liable for the contract entered into by the minor. Minor can be agent, but he cannot be the person responsible for those contracts. In case of joint contract by minor and adult, only adult is liable. Sorry, minor is not liable. Adult can be guarantor for minor. In that case, the ultimate responsibility, ultimate liability is on the adult. Minor may, acting through his lawful guardian, become a shareholder. Company cannot directly allot the share to the minor. Minor is liable for tort, that is civil wrongs. Minor is personally liable for the necessaries, and necessaries are roti, kapda or makan, shiksha, food, cloth, shelter and education, right? Second category, the person who are not capable to enter into the contract are the persons of unsound mind. And three categories of persons of unsound mind: idiot, full-time, unsound. And contract with this person is void. Lunatic, maximum time he is unsound, sometimes he is sound, and he can contract only when he is of sound mind. In case of lunatic, court will presume that contract was entered at the time when the person is of unsound. So the burden of proof in case of lunatic is on the person who says the contract is entered at the time when the person is of sound mind. Intoxicant, the person generally sound, but sometime due to some alcoholics or due to some mental health, he is unsound. And this person cannot enter into contract when he is of unsound mind. The court will presume that contract was entered at the time when he is of sound mind. So in this case, the contract with intoxicant is in the eyes of court is valid. The person who says the contract is entered at the time of when the person is unsound, he has to prove it. The person who are disqualified by law, alien enemies, foreign rulers, corporation, insolvent and convict. So this was the revision. Please prepare the sheet like this for the self-assessment test. Good morning, Kushal, Pawan, Piyush, Kushil, Rajveer. Good morning. So that we can start our self-assessment test. First is the requirement that the parties to an agreement must be competent to contract is laid in section 10, 11, 24, 25. The answer is section 11. Second question, which of the following person do not fall in the category of persons of unsound mind? Idiot, lunatic, alien, drunken person. The answer is alien. As a general rule, an agreement with or by minor is void ab initio, voidable, valid, unlawful. It is void ab initio. In case where a minor enters into an agreement for the purchase of necessaries, then minor is personally liable to pay, minor's estate is liable to pay, minor's guardian are liable to pay. None of these, as minor's agreement is void. The answer is minor's estate is liable to pay. Person of unsound mind are competent to contract, not competent to contract, discharged by law not to enter into the discouraged by the law not to enter into contract, required to enter into contract with the permission of court. Not competent to contract. A lunatic can enter into a valid contract at any time only with court permission if other party has no objection only during lucid interval. Lucid interval का मतलब हुआ when he is of sound mind. A lunatic can enter into a valid contract only during the lucid intervals. A minor can be appointed as an agent, cannot be appointed as an agent, can appoint others as his agent, none of these. A minor can be appointed as an agent without incurring any personal uh, liability. A convict who is sentenced for imprisonment cannot enter into contract throughout his life, cannot enter into contract during the period of imprisonment, can enter into a valid contract even during the imprisonment, can enter into only a contract of marriage. Uh, Answer is a convict who is sentenced for imprisonment cannot enter into contract during the period of imprisonment. A contract is valid, void, ab initio, void, voidable if it is beneficial to minor. Mr. Pawan is saying, sir, section 184 says minor can be appointed as agent. Yes, and on 29th October we will discuss this chapter in details. Okay, so please wait for the 29th. The answer is valid if it is beneficial to the minor. Last question. Which of the following persons are disqualified by law from entering into a valid contract? Disqualified. Alien enemies, insolvent, convicts, all of these. Sir, what is estate of minor? Estate means property which he has. He has all the property which is in his possession, in his ownership, under his ownership. यानी इस पर right है उसका minor का. Akshay sir, please explain me previous slide, previous question number. Please tell me the question number. Right. So this was the self-assessment test, and one thing the student normally ask me कि सर कैसे रिवीजन करें, क्या तरीका होना चाहिए. Just target 10 on 10 in self-assessment test, ऑटोमेटिक रिवीजन हो जाएगा. बस ये सोच लो कि मुझे जो अगले दिन क्लास में होना है सेल्फ असेसमेंट टेस्ट, तो उसमें 10 on 10 लाने हैं, रिवीजन ऑटोमेटिकली हो जाएगा. राइट. सर माइनर कैसे ओन कर सकता है प्रॉपर्टी? अरे भैया, माइनर ने ऐड दिया टीवी में, उससे इनकम हो गई, वो उसकी एस्टेट हो गई. राइट. चलिए, लेट्स स्टार्ट विद सेक्शन नंबर 17, फ्रॉड. We are discussing the unit 3. The part 2 is free consent. In the last class we have discussed section number 15, coercion, section 19, consequences of coercion, section number 16, undue influence, section number 19a, the consequences of undue influence. Now the time to discuss section number 17, fraud. In Hindi it is called धोखा, किसी को cheat करना, fraud, cheat. Fraud means and includes any of the following acts committed by a party to contract or by his agent with intent to deceive, intention to deceive, or to induce a person to enter into a contract. वेरी सिंपल पॉइंट अबाउट सेक्शन 17 की फ्रॉड में ये वाले पॉइंट जो अभी हम डिस्कस करने जा रहे हैं, उसमें से कोई भी काम किया आपने खुद किया, एजेंट के जरिए किया, धोखा देने के उद्देश्य से, किसी को फुसलाने के उद्देश्य से, इंटेंशन टू डिसीव, धोखा देने की इच्छा, इंड्यूस अ पर्सन, इंड्यूस फुसलाना किसी को. तो फॉलोइंग आर द एक्ट which are considered as fraud in the in section 17. First is the suggestion that the fact is true when it is not true and the person making the suggestion does not believe it to be true. Means false statement. In one line, knowingly making false statement. Please note down in your books. Rajveer is asking, sir, what deceive means? Deceive matlab dhoka, cheat. Suggestion that a fact is true when it is not true, and the person making the suggestion does not believe it to be true. Means knowingly making false statement. Please note down in simple language. एक स्टेटमेंट देना ये कह के कि वो सच है जबकि वो सच नहीं है, और जो पर्सन वो स्टेटमेंट दे रहा है उसे भी पता है कि सच नहीं है. So knowingly making false statement. See example number 13. A sells his watch to B by saying that the watch is made in Japan but actually it is Indian, and this fact is known to A. Now A made a fraud. A ने B को घड़ी बेची ये कह के जापानी है पर वो इंडियन थी. Now A has made the fraud. Active concealment, knowingly hiding the facts. जानबूझ के छिपाना is called again fraud. Sir, Pawan is asking, sir, can we write in exam knowingly making false statement? Yes, you can write. Concept is same. Active concealment of fact by person having knowledge or belief of the fact. Again, hiding the facts, knowingly hiding the facts. जानबूझ के किसी सच्चाई को छिपाना. Example number 14. X sells a horse to Y. Horse is blind. And X knows the fact. When Y asks, is horse blind? X clearly says no. Here X made a promise made without any intention of performing. It means you are making the promise but you will not perform it. आप अपना वादा ही पूरा नहीं करेंगे. Again it is any other act fitted to deceive. Any other act done to deceive. कोई और काम जो धोखा देने के उद्देश्य से किया गया. A agrees to double B's gold by magic and runs away with his gold. It is fraud. And any such act or omission as the law specifically declares to be fraud. जब लॉ ने स्पेसिफिकली किसी काम को फ्रॉड बताया. तो there are 5 points. First, knowingly making false statement. Second, knowingly hiding the facts. Promise without intention to perform. Any other act to deceive. Any such act or omission law specifically provides as fraudulent. 5 हो गए. जानबूझ के झूठ बोलना, जानबूझ के बात छिपाना, प्रॉमिस करना पर उसे पूरा करने की कोई इच्छा नहीं होना, कोई और काम जो धोखा देने के उद्देश्य से किया गया हो, साथ में कोई ऐसा एक्ट या ओमिशन जिसे लॉ ने स्पेसिफिकली फ्रॉड बोला. सो प्लीज रिपीट वंस अगेन. knowingly making false statement, knowingly hiding the facts, promise made without intention to perform, any other act to deceive, or any such act or omission as the law specifically declares to be fraudulent. The essential elements of fraud. This part may be important for your examination point of view. There must be a representation or assertion and it must be false. आपने specifically कुछ कहा हो. You have knowingly clearly made the statement and that statement is false. only silence as to fact is not fraud. This line is very much important because the question are many times asked on this point. Mere silence as to the facts is not fraud. See the example number 16. X sells by auction to Y a horse which X knows to be unsound. X says nothing to Y about the horse unsoundness. Please stay on this point only. Question arises whether to sell to auction or to sell through auction unsound horse is void. Answer is no. Let's take another example. If a person is selling his old bike to the person who deals in the these old bikes which are not used for particular persons, एक तरीके से कह सकते हैं कि कबाड़िया, अगर कबाड़िया कोई बाइक खरीद रहा है पुरानी जिसना ब्रेक है ना इंजन चलता है तो क्या वो फ्रॉड है? आंसर इज इट मींस if the person is silent it can not be always be fraud. ये जरूरी नहीं कि वो हर वक्त फ्रॉड हो, क्योंकि पुरानी चीजें अनसाउंड हॉर्स को बेचना भी एक तरीके से लीगल बिजनेस हो सकता है, बट इट कैन बी फ्रॉड. साइलेंस इज फ्रॉड in the such there are some two categories we will discuss. First is there is duty to speak and his silence is speech. In only two categories where silence is fraud. First, duty to speak and his silence is equal to speech. See example number 70. X sells by auction to Y a horse which X knows to be unsound. Y is X's daughter. Here the relation between the parties would make it X duty to tell Y if horse is unsound. यानी कि X ने अपनी बेटी को ही घोड़ा बेचा है, तो यहाँ पर ड्यूटी बनती है X की कि अपनी डॉटर को बताए कि घोड़ा ये है अनसाउंड है, नॉर्मल नहीं है. But another one case where silence is equal to speech. See example number 18. Y says to X, if you do not deny it, I shall assume that the horse is sound. जब अगर तुमने कोई मना नहीं किया तो ये मैं मान लूंगा कि घोड़ा साउंड है. If you do not deny, I will assume the horse is sound. And X says nothing. Now silence of X is equal to speech. Please read example number 17, 18 once again. The representation or assertion must be a fact. Fact means actual thing, not just an opinion. Sir, this pen is blue. This is fact. This pen may be blue. This is opinion. This pen, suppose let's say one pen, this pen is blue. This is fact. मैं जो statement दे रहा हूँ confidently ये blue pen है, ये fact. It may be blue. It is opinion, not fact. And in case of opinion, there is no fraud. In case of opinion, there is no fraud. Example number 19 says, X who is about to sell goods says that the cost him rupees 5,000. This is a statement of fact. But if he says the goods are worth 5,000, it is a statement of opinion. ये 5,000 रुपए का है, ये fact. ये 5,000 का होगा ओपिनियन. So please note, there is only fraud in case of false fact, not false opinion. The representation must have been made with the knowledge of its falsity or without belief in its truth. It means the person making the statement has knowledge that the fact is false, the fact is not true. जो पर्सन स्टेटमेंट दे रहा है उसे पता है कि वो जो बोल रहा है वो झूठ है, राइट. Pawan is asking, sir, in example number 18, X made fraud. The answer is yes. The other party must have been induced to act upon representation or assertion. Means I'm making the false statement. My intention is to make to deceive the person, but the other person is not uh, satisfied with my facts, with my words, and he is not entering into the contract with me. So there is no fraud. मैं जो बोल रहा हूँ वो झूठ है, मुझे पता है वो झूठ है, मेरी इंटेंशन भी है धोखा देने की, लेकिन सामने वाला धोखे में आ ही नहीं रहा, तो फिर फ्रॉड कहां, राइट. तो द अदर पार्टी मस्ट हैव बीन इंड्यूस्ड, फुसलाना, टू एक्ट अपॉन द रिप्रेजेंटेशन और असर्शन, राइट. इफ पार्टी इज नॉट does not enter into contract on the false fact, there is no fraud. अगर पार्टी कॉन्ट्रैक्ट में एंटर होती है पर उन बेसिस पे नहीं जो उसने झूठ बोला है, तो वो फ्रॉड नहीं माना जाए. सी एग्जांपल नंबर 20. A bought shares in a company on the faith of prospectus which contains an untrue statement that one B was a director of the company. A bought shares in a company on the faith of the prospectus which contained an untrue statement that B was the director of the company. A had never heard of B. Therefore, the statement was immaterial from the point of view. A's claim for damages in this case was dismissed because the untrue statement had not induced A to buy the shares. See, what is the case? A company has given a false statement in its prospectus that Mr. B is the director of the company, but actually he was not a director, right? Mr. A says he has bought the share on the belief that B is the director in the company, and so there is fraud with me. I need the compensation. The court says to A, you know who is B? You ever heard the name of B? तो पता है कौन है B? कभी नाम सुना है उसका? जानते हो? A says, no sir, I don't. So how it is possible you purchase the share on the name of the B? तो ये possible कैसे हुआ कि आपने B के नाम पे शेयर खरीद लिए? So the statement is false, but you are not convinced on his name to purchase the shares. So there is no fraud. भले ही आपने शेयर खरीदे, भले ही इंफॉर्मेशन झूठ थी, फॉल्स थी, पर आपने जो शेयर खरीदे उसका बेसिस ये इंफॉर्मेशन नहीं मानी जाएगी, एंड दैट्स व्हाई देयर इज नो फ्रॉड इन द एग्जांपल नंबर 20. प्लीज रीड इट वंस अगेन. Miss Goramba is asking, sir, these examples will come in exams. No. Practical problem, descriptive problem will come in the exam. So you have to solve that problem with the provisions of these sections, right? The party must have been relied upon the representation and must have been deceived. आप झूठ बोल रहे हैं और आपकी बात पे कोई यकीन नहीं कर रहा है, तो देयर इज नो फ्रॉड. यकीन भी कर लिया लेकिन धोखा नहीं हुआ, then it is not fraud again. You are making a false statement and no one is believing on your statement. There is no fraud. Mr. X is believing in your statement, but he is not deceived. Again, there is no fraud. See the example number 21. T bought a Canon. You seeing the Canon on the slide? From H on credit. T bought a Canon from H on credit. The Canon was defective, but H had plugged gunpowder in. T did not examine the Canon, but when he used it, it burst. Held the plug had not deceived T. अरे आपने तोप खरीदी, you have purchased the Canon, but if you don't give in the message to the seller about the use, then seller is not responsible. So in this case, because the Canon is on credit, the seller has right or buyer is liable to make the payment, right? The other party acting on the representation must have been subsequently suffered some loss. If there is no loss, what will you claim? अगर लॉस ही नहीं हुआ तो क्लेम क्या करोगे? So there must be a false statement. Other party has been induced by this false statement. Other party has acted on that false statement, and there is some loss to other party on this false statement. Then the fraud is there, right? And what are the consequences of fraud? First is contract is voidable at the option of the parties whose consent was obtained by fraud. जिसके साथ धोखा हुआ है वो उस कॉन्ट्रैक्ट को तोड़ सकता है, but until it is avoided, important thing, until it is avoided, it is perfectly valid. And the party defrauded, the following remedies are there. He can resign the contract, cancel the contract, avoid the contract, and he can insist on the performance of the contract on the condition that he shall be put in the position in which he would have been if representation made had been true. इस लंबी सी लाइन के बदले में एक छोटा सा लिख लो, he can insist on the genuine performance. He can insist on the genuine performance. And last, he can sue for damages, for compensation. Now the query on this point from your side, that in example 21, seller is not liable as it is on credit. No, seller is not liable as there is no fraud on his part and he can receive the payment, right? And fifth point, again I'm saying, see point number 5. The party have been relied on the false statement. Again, it is case of silence. एक आदमी तोप खरीद रहा है, हो सकता है उसे तोप घर के बाहर लगानी हो, जरूरी थोड़ी ना है कि उसे यूज ही करनी हो, उड़ाना हो किसी को, राइट? Important point. These 3 points are important for your examination. Contract not necessarily voidable, they are exception. It means in these points, contract is not voidable. The parties whose consent is obtained by fraud has no right to avoid the contract in these situations. First, where the consent of a party to contract was caused by silence amounting to fraud, and that party could discover the truth by ordinary diligence. अगर आपके साथ फ्रॉड हुआ है और you can find out the fraud, you can find out that there is fraud with you, by using your ordinary diligence. थोड़ा सा दिमाग लगाते दिख रहा था आपको तो फ्रॉड हो रहा है, फिर भी आपने आंखें बंद कर ली. फॉर एग्जाम्पल, you ask Mr. X about the shirt. He said, please, I need a shirt. एक दुकानदार है, एक शॉपकीपर है, Mr. X, and you ask the shirt from shopkeeper, and the shirt is defective. A defect is on the front of the shirt. You can see, and you are asking the shopkeeper, sir, there is any defect in the shirt? He is saying, no, sir, there is no defect. You are you seeing the defect, but you believing in the words of shopkeeper. In this case, you cannot avoid the contract because you can discover that there is fraud with you. Second point, where the third party has acquired an interest in the property for value. It means, for example, you can say that if you purchase a defective, there is fraud with you, and you purchase some defective items, right? And you have sold this item to another person. आपने कोई defective shirt खरीदी, उसमें defect था, और आपको पता आपका फ्रॉड हुआ है, फिर भी आपने किसी और को बेच दी. Where the third party has acquired an interest in the property for value, so you cannot resign them. Where the party, after becoming aware of the misrepresentation of fraud, takes benefit under the contract or some other way of formation. आपको पता है, you know there is fraud with you, and you have confirmed, okay sir, that's no problem, I can use this shirt. घर में पहुंच की जरूरत थी, हम उसको यूज कर लेंगे, पर शर्ट को यूज कर लेंगे. So in these cases, you cannot claim, you cannot avoid the contract, right? Now, misrepresentation. This is again a false statement, but genuinely. आपको पता नहीं था, आप झूठ बोल रहे हो. Misrepresentation, section number 18, is wrong done without intention to deceive. In fraud, you know you are making a false statement, but in misrepresentation, you don't know, you don't have the idea that you are making the false statement. According to section 18, there is a misrepresentation when a person positively states that a fact is true when his information does not warrant it to be so. वो कह रहा है कि वो सच बोल रहा है, पर वो ऐसा नहीं है. See example number 22. X says Y that this bike runs 70 kilometers per liter. X believes that he is true, but actually bike runs 40 kilometers per liter. It means X is making a false statement without knowledge, innocently. If the false statement is innocent, then it is misrepresentation. When false statement is made knowingly, then it is fraud. जानबूझ के झूठ बोलना फ्रॉड है, और अनजाने में बोलना misrepresentation. When there is breach of duty by person without intention to deceive, which brings an advantage to him and loss to others. Again, same thing. You have to do something, but you could not do because some reason you don't have any intention to deceive, but you get some profit and other party got some loss. See, while taking an insurance policy, X states that his age is 25 years, believing it to be true. Actually, he is 30 years old. Now he is guilty of misrepresentation, not fraud. Clear? When party causes the other party to agreement to make a mistake as to the subject matter, यानी कि अदर आप किसी पार्टी को कॉन्टेक्ट कर रहे हैं, when you are entering to contact with the other party so that he could make some mistake, but you have, again, you don't have any intention to deceive or fraud. Consequences of misrepresentation, same as fraud, but only one difference. You cannot claim compensation. Mr. Jakir, अभी आपकी जो आपका you have raised the hand, but we will take the query after first part of this class. ठीक है, so please wait, or else you can send the query on the portal. The aggrieved party, in case of misrepresentation by the other party, can avoid or resign the contract or accept the contract but insist that he shall be placed in the position in which he would have been if the representation made had been true. Simple language, he can avoid the contract or he can insist for the genuine performance. भैया genuine होता है वो आप करा, right? So these are the differences. I am not taking here. You can read yourself. It is also in your study module. Now, mistakes, section 20, 21, 22. Erroneous belief, गलत गलत विश्वास किसी के ऊपर about something like 2 plus 2 is equal to 5. A mistake may be of law, mistake of effect, mistake of law of our country, and mistake of law of foreign country. Mistake of fact is classified as a bilateral mistake and unilateral mistake. Bilateral mistake means the mistake under which both the parties under contract are under mistake. In case of unilateral mistake, only one party is mistake, right? Mistake of law. Mistake of law of country. I think you can understand this concept with the line that any person of the country is presumed to have the knowledge of the law of country. अगर कोई मैं इंडिया में रहता हूं, मुझे उम्मीद है कि मुझे ये जानकारी, मैं ये माना जाएगा कि मुझे अपने देश के कानून की जानकारी होगी. A person cannot be allowed to get any relief on the ground that he had done a particular act in ignorance of law. कोई भी इंसान ये नहीं कह सकता अपने देश की कानून की जानकारी नहीं थी, उसने गलती से काम कर दिया. Suppose you are crossing on the red light and you are saying that I don't have the knowledge ki whether I have to stop my vehicle on red light, right? So a person cannot be allowed to get any relief on the ground that it had done a particular act in ignorance of the law. Let's see the example number 24. A and B enter into a contract on the erroneous belief that a particular debt is barred by the Indian law of limitation. This contract is not voidable. Simple, sir. A person is believing that debt is already time barred, but actually it is not. You are thinking that it is time barred because you don't have the knowledge of law. You cannot get relief on this point. I don't have the idea what is the time limit for being a time barred. Mistake of law of foreign country means, you can say in this way, कि a person of foreign country can be presumed that he would not have a knowledge of our law. Such a mistake is treated as mistake of fact, and agreement in such a case is void. Means if a foreigner has made a mistake due to ignorance of Indian law, this contract is void. This cannot be claimed. But in case of you are entering in a contract, you cannot say that you don't have the knowledge of law. It means you have to perform even you have entered into a contract in the ignorance of law. आप किसी अपने देश के कानून की जानकारी के मतलब अभाव में, you don't have the knowledge, कि आपको लॉ की जानकारी नहीं थी, आप कॉन्ट्रैक्ट कर लिया आपने, बाद में मालूम पड़ा ये तो गलत है, आपको पेनल्टी लगेगी. You will be penalized. Even you can say, sir, मुझे पता ही नहीं था, सर मुझे आइडिया ही नहीं था, right? Mistake of fact, bilateral mistake. Both the parties are under a mistake as a matter of fact. Both the parties, agreement is void. And this mistake can be of existence of subject matter. See an example. A and B are entering into a contract in which A will let out his flat to B. A and B are entering into a contract in which A will let out a flat to B. Agreement is going to be signed. But at the time of signing the agreement, both parties A and B was unaware that that building was demolished. अब both parties are under mistake. ना A को पता था ना B को पता था. In this case, contract is void. Mistake as to finding the identity, as to the quality, as to the quantity, ownership title. If both parties under mistake, the contract is void. This mistake is called mistake of fact. Again, mistake as to the possibility of performance. Physical impossibility means physically impossible to perform. Legally impossible means physically possible to perform, but as per law it cannot be performed. In this case, contract is void. Possible नहीं है perform करना, impossible है, contract void. Possible है, but law has made the restriction, law has made the prohibition on performance of this act. Means possible but not legally possible. Again, it is void. Unilateral mistake, mistake on the part of one party only. One party is under mistake, not other. In this case, the party under the mistake cannot avoid the contract. एक की गलती पर दूसरा भुगतान नहीं करेगा. One cannot be punished on the mistake of one person. So in this case, when in the contract, when there is only mistake on the part of only one party, the other party cannot be suffered. So in this case, contract will be perfectly valid. So listen, in case of, please listen carefully. This is very much important what I'm going to say. In case of 15, 16, 17, 18, coercion, undue influence, fraud, misrepresentation, coercion, undue influence, fraud, misrepresentation, contract is voidable at the option of the parties whose consent is not free. 15, 16, 17, 18 इस केस में कॉन्ट्रैक्ट voidable होता है, void नहीं होगा. And till voidable, till avoided by the party has a right to avoid it, it is perfectly valid. जब तक पार्टी उसे अवॉइड नहीं करेगी ये वैलिड रहेगा. बट इन केस ऑफ मिस्टेक, in case of mistake of Indian law or unilateral mistake, contract is valid. In case of mistake of foreign law or bilateral mistake, contract is void. So in case of mistake, contract either valid or void. Indian law, law of country, or unilateral, perfectly valid. Mistake of fact and bilateral mistake, bilateral mistake, mistake of fact, and mistake of foreign law is void. Clear? So now time to super over 3. अगर कोई query है, if you have any query, you can send on the portal. Mega ma'am is there? मेगा मैम आप हैं क्या क्लास में?
जी सर.
मैम क्वेरी अभी लें या लास्ट में ले लें एक ही बार?
सर अभी भी ले सकते हैं, फिर 5 मिनट्स का ब्रेक करने के बाद आप सेशन कंटिन्यू कर सकते हो.
ठीक है मैम. अभी एक बच्चे की क्वेरी है सर, इसको जरा कर दीजिए, अलाउ कर दीजिए.
भार्गव,
एक बच्चे
स्टूडेंट्स को
को अलाउ
अनम्यूट
कर
कर
दीजिए.
दीजिए.
सुवश है.
सुभाष अधिकारी. सुभाष अधिकारी. यस. क्या कह रहे हो आप? चैट नहीं, स्टूडेंट्स को अनम्यूट का ऑप्शन दे दीजिए फॉर 5 मिनट्स ओनली.
सुवश बोलिए प्लीज.
गुड आफ्टरनून सर.
गुड आफ्टरनून।
सर, मैं ये बोल रहा था कि ये जो आपने ये सॉरी सर, कंपनी जो एडवर्टाइजमेंट करती है अपने प्रोडक्ट को, तो उसमें उसका जो पूरा डिटेल्स रहता है बाइक वगैरह का,
हम्म।
माइलेज या तो वो वो किस तरह का एडवर्टाइजमेंट करते हैं सर?
देखिए, जो एडवर्टाइजमेंट आते हैं लिखा होता है माइलेज ऑफ बाइक 91 किलोमीटर पर लीटर, पर वो उनका चेक किया होता है अल्टीमेट एट द बेस्ट सर्कमस्टांसेस। उनका बेस्ट होता है, जरूरी नहीं कि वो हर समय वही आएगा। इसलिए वो भी फ्रॉड नहीं होते, उन्होंने कहीं ना कहीं से रिपोर्ट ली होती है। जब वो अपना एड देते हैं तो प्रॉपर कोई रिपोर्ट के साथ देते हैं कि साहब हमने इसका बेस्ट ये निकाला है। तो जो वो मेंशन करते हैं एवरेज आ रहा है, दैट इज द बेस्ट एवरेज एट एनी पॉइंट ऑफ टाइम, राइट। तो यू कैन नॉट से
यस
कि वो दैट इज फ्रॉड, क्योंकि नीचे लिखा होता है ना स्टार में कंडीशन अप्लाई, वो भी पढ़ना
यस
होता है। ओके।
ओके,
पीयूष प्लीज
थैंक यू सर।
आस्क। ओके, थैंक यू। यस पीयूष। Okay, I think Piyush is not asking. So let's start the super over 3. After this super over, we will have a break of 5 minutes and then we will complete
Sir, I have a doubt.
this. Please ask. Please.
सर, void ab initio का मतलब क्या है?
Void ab initio. Ab initio means from very beginning. स्टार्टिंग से जब आप सोच रहे हैं उसके बारे में, तभी से void हो जाता है। स्पेसिफिकली लॉ ने बोला है कॉन्ट्रैक्ट विद माइनर इज void ab initio। माइनर के संग तो कॉन्ट्रैक्ट सोचना भी नहीं है, राइट।
सर आंसर कहाँ पे भेजें?
आंसर आपको भेजने हैं पोर्टल पे, जो ऐप है ना आईसीआई की, वहां भेजिएगा और एक साथ भेजने हैं सबको, ठीक है ना। मतलब एक साथ सारे आंसर, जो 6 क्वेश्चन आएंगे वो 6 के 6 आपको आंसर एक साथ भेजने हैं, ठीक है। लेट्स स्टार्ट द फर्स्ट क्वेश्चन। ए प्रॉमिस मेड विदाउट इंटेंशन ऑफ परफॉर्मिंग इट अमाउंट्स टू मिसरिप्रेजेंटेशन, फ्रॉड, कोर्शन, नन ऑफ दीज। Second question. Which of the following is not included in the term fraud? Concealment of facts in good faith, when the court declares it fraudulent, when it is made with intention to deceive, promise made without intention to perform. Third question. A false statement of facts made without any intention to deceive the other party falls under the category of fraud, undue influence, coercion, misrepresentation. An agreement for the sale and purchase of horse which, unknown to both the parties, was dead at the time of bargain is void, valid, voidable, illegal. The aggrieved party, that is the parties whose consent was obtained by fraud, may resign the contract only. Resign कर सकती है केवल. May affirm the contract only, or may resign or affirm the contract. None of these. Mistake of foreign law is treated in the same manner as mistake of Indian law, mistake of fact, misrepresentation, fraud. Mistake of foreign law. waiting for 1 minute. Till then, you please send the answers. Two students has sent me the answers. Okay, so let's start. A promise made without intention of performing it amounts to fraud, which is not included concealment of facts in good faith. False statement of fact made without any intention to deceive, misrepresentation. Agreement for sale and purchase of horse, which unknown to both the parties was dead at the time of bargain, is void. Bilateral mistake. Resigned or affirm. Foreign law is the same as mistake of facts. So let's see. First one who has given all the correct answer is Miss S. Nandini. Congratulations. Kanika Agrawal. Congratulations. Kaushal. Congratulations. Rajveer. Congratulations. Shoaib Ali. Manasvi. Congratulations both. Lakshman. Congratulations. And Pawan. Congratulations all of you. Now we would have a break of 5 minutes and after that we will come to the part number 3 of this unit. ठीक है, तो बच्चों यहाँ ब्रेक ले रहे हैं 5 मिनट का. We will rejoin. ठीक है. Okay, so let's start the last part of the unit number 3. Part number 3, legality of object and consideration. So we are discussing section number 23, unlawful objects and consideration. First, in the following cases, the object and consideration are considered as unlawful and that's why the contract is void. जो हम डिस्कस करने जा रहे हैं ये वो केसेस हैं जहां पर ऑब्जेक्ट या कंसिडरेशन या दोनों ही अनलॉफुल है और बिकॉज ऑफ बीइंग अनलॉफुल the contract is void. First, if it is forbidden by law to do some act, the object is so that it is forbidden by any law, it is unlawful. कोई ऐसा काम करना जिसे लॉ ने मना किया हो, it is unlawful and contract is void. See the example number 25. अब A contracted with B to deal in stolen goods, चोरी के माल को डील कर रहा है. It is forbidden by law and therefore it is. If it is in such a nature, just a moment. Okay. If it is of such a nature that if permitted, it would defeat the provisions of any law, means it is not directly prohibited by law, it is indirectly prohibited by law. Not directly prohibited by law, but indirectly prohibited by law. Even in that case, it is unlawful and contract is void. See the example number 26. A was licensed under as Excise Act to run a liquor shop. The Act forbade the creation of partnership to run the shop. A took B into partnership. The agreement is void. A has the license to deal in the liquor shop. License is valid. He has right to deal in the liquor shop because he has the license. But law specifically prohibited to do this business under partnership. And if A makes a partnership with B, contract is void. But I'll just take one more example. A has the license of beer shop, of liquor shop, and due to some fault in the compilation of law, in compliance of law, the government has cancelled the license with the condition that this license is permanently cancelled for this person and this person can never run this liquor shop in the future. कि एक मिस्टर सपोज ए थे, इनके पास लाइसेंस था लिकर शॉप का और कुछ उन्होंने टर्म्स एंड कंडीशन का अवॉइडेंस किया, इस वजह से क्या हो गया, उन्हें लिकर शॉप का लाइसेंस ले लिया गया, वापस कर दिया, कैंसिल हो गया. गवर्नमेंट ने कहा कि दिस पर्सन, ये आदमी दोबारा इसका मालिक नहीं बनेगा. This person cannot apply in future again for a license, right? Now what happened? A entered into a contract with B. A entered into a contract with B with the request कि B, please take the license of the liquor shop and after that I will do the business for this. I will make you payment, everything with you. So the contract between A and B is void because it indirectly defeats the provisions of the law or the order of the government. A को तो मना हो गया, ए ने बी से कहा कि भैया तुम मेरी जगह लाइसेंस ले लो, तुम बिजनेस करो, लेकिन मैं पैसा लगाऊंगा, सब कुछ मैं करूंगा, प्रॉफिट भी मैं कमाऊंगा, तुम्हें कुछ शेयर दूंगा। तो ए और बी के बीच में जो कॉन्ट्रैक्ट है, दिस इज वॉइड अनलॉफुल, राइट? If it is fraudulent, if any business, any contract is done, any contract is done on the object to make fraud, it is always unlawful and void. See example number 27. A, B and C enter into a contract, into partnership to run the business of fraud and distribute the earning in equal ratio. The agreement is void, right? What happened कि भाई ए और बी ने कॉन्टेक्ट किया कि सर ऐसा करते हैं, एक बिजनेस करेंगे, क्या कि रात में ना जो क्रॉसिंग पे ट्रक निकलते हैं ना लूटेंगे और सब शेयर कर लेंगे। दिस इज फ्रॉड। इफ इट इन्वॉल्व और इम्प्लाइज इंजुरी टू द पर्सन और प्रॉपर्टी ऑफ अदर, किसी की प्रॉपर्टी को किसी पर्सन से पहुंचाने कॉन्ट्रैक्ट क्या होगा? वॉइड, अनलॉफुल। ए कॉन्ट्रैक्ट विद बी टू बर्न द हाउस ऑफ सी, as contract involves the property of C, contract is unlawful and A ने कॉन्ट्रैक्ट किया B से किसी का घर जला दो, कॉन्ट्रैक्ट क्या है? अनलॉफुल। if the court regards as immoral, bad character. Example number 29, please see. A asks B, if you arrange a girl for marriage with me, I will give you 50,000. This contract is immoral, bad character contract. Arranging a girl for marriage is a bad character contract. It is immoral and hence void. When the court regard it as opposed to public policy, if court says that contract is against the public, it is harmful for the public, it is void. So these are the cases I am discussing before you, the cases in which contract is considered opposed to public policy. अभी जो हम चर्चा करने वाले हैं वो ये है कि वो केसेस है, वो लिस्ट है जहां पर कॉन्ट्रैक्ट क्या है? अपोज टू पब्लिक पॉलिसी माना जाएगा और वो वॉइड होगा। फर्स्ट इज ट्रेडिंग विद एनिमी। इफ यू आर डीलिंग विद द सिटीजन ऑफ अ एनिमी कंट्री, द कॉन्ट्रैक्ट इज वॉइड। Second point, in every batch I have given this lecture, every class, one query, sir, what is stifling prosecution? So please listen this carefully. Stifling prosecution, to shift from the prosecution. If one person should be prosecuted by law and you are entering into contract to for avoiding him from the prosecution illegally, it is void. C, it is an agreement to abstain from prosecuting a person for an offense. Yani if person made an offense and he should be punished, he should be prosecuted, and you are entering into a contract to abstain him, it is void contract. A promises to drop a prosecution which he has instituted against B for robbery. So robbery is a crime. If B has made a robbery, he should be punished. Whether the robbery for 1 rupee, whether robbery for 1 lakh rupees. But B has made the robbery against A. B has made the robbery against A, and A promised that if B restores his stolen property, A will drop the prosecution suit. The agreement is void. But some offenses, specifically in the list of IPC, you can say, which are compoundable, which can be settled. So compromise in case of compoundable settable offenses is valid. Please read it. Rajveer saying, sir, marriage bureau, I am coming to this point, beta. And sir, what in case of lawyer prosecutes a convicts? देखिए, lawyer is a professional person in working on the evidence provided to him. Final decision is on the judge, right? If someone affect the will of any person, then it will fall under the injury or person or not. If someone affect the will of any person, it will come to the category of no free consent. Right? Now, maintenance and champerty. Please listen. I'm discussing, I'm giving you two examples, and these two examples will clearly make you understand the concept of maintenance champerty, because this is again a point on which question arises. Let's say A asks B, listen carefully. A asks B, please file to her fee, and I will pay all expenses to you for this purpose. This is the case of maintenance. This contract is void. But with this contract, one additional line is added. A asks B, please file a fake suit against C. I will maintain all the expenses, maintenance. And if you will get any compensation from C, if you get any compensation from C, I will share it. Then it is the case of chamfer. दोबारा सुन लीजिए, हिंदी में बोल रहा हूं. ए ने बी से कहा कि तुम सी के खिलाफ एक फेक केस फाइल कर दो, जितना खर्चा होगा वो सारा मैं मैनेज करूंगा. दिस इज द केस ऑफ मेंटेनेंस. दिस इज वॉइड. इट मींस we cannot claim anything from A. एक लाइन और ऐड हो गई. अगर इस केस में आपको सी से कुछ मिला, कुछ रिकवरी हुई, कॉम्पनसेशन, तो उसमें मेरा भी हिस्सा होगा. दिस इज द केस ऑफ चैम्पर्टी, एंड दिस इज अगेन void. So all both maintenance chemparty are void agreement. But please listen, what is this? Maintenance is an agreement to give assistance, financial or otherwise, to another to enable him to bring or defend a legal proceedings when the person giving assistance has got no legal interest of his own in the subject. It means who is supporting not getting any legal. A offers to pay B rupees 2000 if B will sue C. A's motive is to hurt C. This agreement between A and B is maintenance agreement. Champerty is an agreement whereby one party is to assist another to bring an action for recovering money or property, and is to share in the proceeds of the action. Is to share in the proceeds of action. It is champerty. A agrees to pay the expenses if B sues C, and B agrees to give a one half of any proceed received by B as a result of the said suit. If the object of a contract is just to assist the other party in making reasonable claim arising out of the contract, then to have a fair share in the profit, this is valid. Fair share, reasonable claim, valid. But fake claim, unreasonable share, it is invalid, unlawful. Right? So I think now you are clear what is maintenance and champerty. ठीक है? एक बार पढ़ लीजिए बच्चों इसको. Please read once again. interference with the course of justice, to interfere in the justice judgment proceedings. An agreement to pay a bribe of 5 lakh to a judge to change his decision is unlawful and void. It means if you enter into agreement with a judge for change the decision and you offer 5 lakh rupees, and if judge has done, he cannot claim the 5 lakh rupees from you because the agreement was unlawful and void. Marriage brokerage, commission baji, dalali, these contracts are void. One person is asking, sir, what about the marriage bureaus? So marriage bureaus are just charging consultancy fees. They are not charging the brokerage on the expenses done in the marriage. If they are charging the brokerage on the expenses done in the marriage, the contract is void. An agreement to negotiate marriage for reward bargaining, which is known as marriage brokerage contract, is void as it is opposed to public policy. An agreement to pay money to a person hired to procure a wife is opposed to public policy and therefore it is void. Anshuman is asking, सर इसमें पार्टी का इंटरेस्ट होना जरूरी है, जैसा आपने एग्जाम्पल दिया उसमें बी सू कर रहा है सी, उसमें तो बी को कोई इंटरेस्ट नहीं था. देखिए, यू आर नॉट गेटिंग द कंसेप्ट, प्लीज ट्राई टू अंडरस्टैंड. ए ने बी को कहा कि आप सी के ऊपर केस फाइल कर दो, तो इस केस में अगर ए को कोई इंटरेस्ट नहीं है तो वो मेंटेनेंस है, और ए को सिर्फ ये इंटरेस्ट है कि जो पैसा मिलेगा सी से उसमें शेयर करेगा, दैट इज चैम्बर्ड, राइट. Person taking leave from work by asking his boss is promise or contract as there is no consideration for boss. ये भाई साहब ने क्वेश्चन पूछा है कि एक आदमी नौकरी पे छुट्टी ले रहा है, तो ये प्रॉमिस है या कॉन्ट्रैक्ट है? दिस इज नॉट अ प्रॉमिस और कॉन्ट्रैक्ट, दिस इज रिक्वेस्ट फ्रॉम द साइड, फ्रॉम योर साइड टू द बॉस, एंड बॉस विल टेक द डिसीजन एज पर द एग्रीमेंट, सर्विस एग्रीमेंट. जो कॉन्ट्रैक्ट हुआ था आपका एट द टाइम ऑफ अपॉइंटमेंट, उसके अकॉर्डिंग. तो यू आर जस्ट फुलफिलिंग, द बॉस इज जस्ट फुलफिलिंग the conditions on the agreement. If in the agreement you are allowed to get the leave, you will be allowed, otherwise not, right? Interest against obligations means duties, means if you have the duty, you have some duty, you cannot claim any consideration for it. You are already bound to this. See the example. Following are the examples of agreement that are void as they tend to create an interest against obligations. It means you are liable to, you have to perform your duties and again you are charging something. It means interest against duties, obligations. The object of such agreement is opposed to public policy. An agreement by an agent to receive without his principal consent compensation from another for the performance of his agency is invalid. Means the principal has appointed an agent for particular work, and without the knowledge, without the consent of principal, agent is charging some remuneration, some brokerage, some commission from third party. It is invalid because it's a duty of an agent to work as per the direction of the principal. A, who is manager of the firm, agrees to pass a contract to X if X pays ₹2,000 privately. This is again void. Right? Now, sale of public offices means sale of public post, job, service, charging any money for placement. Agreement for sale or transfer of the public offices and titles or procurement of public recognition like Padam Vibhushan, Paramveer Chakra for monetary consideration. It means you are paying some money to get the reward like Padam Vibhushan, Paramveer Chakra, and this is void, unlawful, against the public policy. See an example, an agreement to pay money to public servant in order to induce him to retire from his office so another person may secure the appointment is void. It means an agreement by the public servant for some money. Please get the retirement and you will get the money and I will take that position. कि भैया आप रिटायरमेंट ले लो मैं आपको पैसे दूंगा और इस पोजीशन मुझे जगह मिल जाएगी. This is void contract opposed to public policy. An agreement to procure a public recognition like Padma Vibhushan for reward is void. साहब मैं पैसे दे दूंगा मुझे ये अवार्ड दिलवा दो. This is again void. Agreement for creation of monopolies. Right? See, if I enter into a contract with the Nagar Nigam, local authority, that I will pay rupees 1 lakh if authority allow only my vegetable cart in this vegetable market. मैंने नगर निगम से कॉन्टेक्ट किया कि मैं आपको 1 लाख रुपए दूंगा केवल मेरी ठेल लगनी चाहिए सब्जी की बाकी किसी की हटवा दो. This contract is a contract to creation of monopolies and these type of contract are always void. Because if there is monopoly, there is a loss to the customer. So law says agreement having for their object the establishment of monopolies are opposed to public policy and therefore they are. See the example. A contract with municipal corporation for disallowing all the shopkeepers from the market other than A and this contract is void. A ने कॉन्टेक्ट किया म्यूनिसिपल कॉर्पोरेशन से कि भैया आप बाकी को डिसअलाउ कर दो केवल ए को अलाउ करना उस मार्केट में अपनी दुकान लगाने के लिए. ये कॉन्टेक्ट क्या है? void. Right? So now some agreements which are specifically declared void by law. कुछ इसमें से हम पढ़ चुके हैं और कुछ एक दो चीज रह जाएंगे वो अभी डिस्कस करते हैं. Agreement by incompetent parties, section 11 we have already discussing. Agreement made under a mutual mistake of fact, section 20 we have already discussed this topic. Agreement the consideration or object which is unlawful, section 23 we have already discussed. Agreement the consideration or object of which unlawful in part, not fully, it is part, void. If any part of a single consideration for one or more object or any one or any part of one or more several consideration for single object is unlawful, the agreement is. Agreement made without consideration, section 25 void, but some exceptions are there. We have discussed in the third lecture. Agreement in restraint of marriage. Any agreement in restraint of marriage other than child marriage is void. किसी को शादी करने से रोकने कॉन्ट्रैक्ट void होगा, लेकिन चाइल्ड मैरिज क्योंकि इलीगल है तो उसको रोकने कॉन्ट्रैक्ट void नहीं होगा. Every agreement in restraint of marriage of any person other than a minor is void. So if a person being a major agrees for good consideration not to marry, the promise is not binding. Agreement in restraint of trade, किसी को व्यापार करने से रोकना, restraining a person from trading anything, for restraining a person from doing business is void. An agreement by which any person is restrained from exercising a lawful profession, trade or business of any kind is to that extent is void. Right? But this rule is subject to some exceptions. Some exceptions are there for this rule, section number 27 के लिए. Exception to point number J, point number 7. This is not point number J, it is point number 7. Sale of goodwill. A seller of goodwill of a business may be restrained from carrying on a similar business within specified local limits, provided that such limit appears to the court reasonable regard being had to the nature of business. See the example. Let's see there are two shops nearby. One is for Haldiram sweets and one is for Jaldiram sweets. And Haldiram sweets has the goodwill. The shop are of the same size, right? Same market. Normally, the sale value of the shop of Haldiram will be higher as comparison to the Jaldiram, right? But what is the reason behind it? Why the price of the shop of Haldiram is higher? Because of goodwill, right? So one person is selling the shop, the Haldiram is selling his shop to Mr. X, and X is making the higher payment just because of the goodwill. It means X is buying the goodwill from Haldiram. Now X can make the restriction on the Haldiram on carrying on the similar business, not other business, similar business in the same local area within the specified local limits, or on such conditions, such terms which are reasonable as per the code. हल्दीराम ने अपनी दुकान बेच दी ज्यादा प्राइस पे बिकॉज ऑफ गुडविल कि भाई इसकी गुडविल अच्छी थी, ज्यादा बेच दिया. अब जो पर्सन गुडविल खरीद रहा है वो रेस्ट्रिक्शन लगा सकता है हल्दीराम पर कि आप इस पर्टिकुलर एरिया में पर्टिकुलर रेस्ट्रिक्शन के साथ सिमिलर बिजनेस नहीं करेंगे. बट दिस रेस्ट्रिक्शन शुड बी रीजनेबल एज पर द कोड. कोर्ट चाहे तो इन्हें हटा सकता है अगर उसे लगता है दीज रेस्ट्रिक्शंस आर नॉट. क्लियर इतनी बात? प्लीज रीड इट केयरफुली. Rajveer is saying, sir, I am confused between reasonable terms and unreasonable terms. देखिए एक्चुअल में तो दिस विल बी डिसाइडेड बाय कोर्ट, बट यू मे से, you may take the example कि मान लीजिए in that case हल्दीराम रिक्वेस्ट कि सर प्लीज मेक द रेस्ट्रिक्शन ओनली फॉर 6 months. Beyond it, it will be harmful for me. I have to close my all businesses. And court is satisfied that the request of the Haldiram is good. ठीक है, genuine है. It can make the restriction on these terms and conditions. That maximum restriction time is 6. Right? Sir, can we write this PPT which you provide to us? Yes, you can write it because this is from your study module also. Pawan is asking, sir, goodwill being intangible asset, how can anyone sell it? Question is good, but I think all of you are the commerce student, and you are getting the knowledge of accounting from the class 11th, and in that case the concept of sale of goodwill, the value of goodwill has been make you understand. But I am taking this point. I am just taking the example of Haldiram and Jaldiram. The value of area of the shop, both shop, one is of Haldiram and one is for Jaldiram, is same. Even shops are just adjacent to each other, जुड़ी हुई हैं दोनों एक दूसरे से. Even that case, the value of shop of Haldiram will be higher than value of shop of Jaldiram because of goodwill. So this is the goodwill, right? So he is charging any extra point, any extra cost, it is the cost of goodwill, right? Partners agreement. A partner shall not carry on any business other than that of firm while he is partner. It means a partner can enter into a partnership firm with an agreement that till he is partner in the firm, he will not do any individual business. जब तक आप फर्म में हैं अपना बिजनेस नहीं करेंगे. This agreement is perfectly valid. It cannot be said that this agreement is restraining to doing the trade. B point, an outgoing partner leaving the firm may agree with his partners not to carry on the similar business as that of firm within a specified period or within specified local limits. कि जो पार्टनर छोड़ के जा रहा है वो ये एग्रीमेंट कर सकता है कि जब वो जा रहा है तो कोई पर्टिकुलर समय तक पर्टिकुलर एरिया में सेम बिजनेस नहीं करेगा. He should not be a competitor for the firm. C point, partners may, upon or in anticipation of the dissolution of firm, make an agreement that some or all of them will not carry on the business similar that of firm within a specified period or within a specified local limits. It means when the firm is dissolved, so there may be an agreement among the partners. Some of all, yeah, all of them will not carry on the similar business within the specified time period or within the specified local limits. This type of agreement is again valid. D point, where the goodwill of a firm is sold after dissolution. Just you can say the sale of name of the firm. I'm selling the name of the firm. You can use my name. You can use the name of my firm. I'm selling the business. A partner may carry on the business competing with that of the buyer, and he may advertise such business. अगर एक आदमी केवल गुडविल खरीद रहा है यानी हमारा नाम यूज करने के लिए पैसे दे रहा है वो, तो जो पार्टनर थे पुराने, they can carry on the similar business and also can use the also can advertise their business, but they cannot use the name of the firm. Subject to the agreement between them, it means there may be an agreement among the partner and the buyer of the goodwill that old partner will not use firm name, it is valid, will not represent himself as carrying on the business of the firm, he will not represent in the market that he was the actual owner of the firm. कि पहले तो भाई साहब मैं ही चला रहा था, मजबूरी आ गई मेरी, तो नहीं, he cannot use this type of thing. He cannot solicit customs of persons, customer, he cannot demand the customers to of the old firm. It means वो ये नहीं सकता भाई साहब फर्म बेची है, आदमी मैं यही हूं, मैं ही बना रहा था, सारा माल आपको दे रहा था मैं. It is, if this type of agreement is done between the partners, old partners and the buyer, they are perfectly valid. Any partner, E point, any partner upon the sale of goodwill of a firm make an agreement with the buyer that the such partner will not carry on the business similar to that of firm within a specified period or within a specified local limits. This agreement may be done. If person is selling, if partnership firm is selling his goodwill, matlab it means if a partner firm is selling its name to another person, so the buyer by agreement make the restriction that partner will not carry on the similar business but up to a particular time or in particular area. So these points A to E are valid, even they are restricting the trade, they are restricting the right to trade, they are valid. So please read it carefully. 1 मिनट टाइम दे रहा हूं बच्चों आपको, प्लीज को एक बार दोबारा पढ़ लो. Soumya is asking, sir, I asked out of the topic question, but my question is why we can't show goodwill in the balance sheet. I think this question should be asked from the Sanket sir. Once please you ask Sanket sir, क्योंकि मेरी accounting बहुत कमजोर है बच्चों. Please ask. Now trade combination, union, trade unions, लोहा व्यापार उद्योग, cycle trade unions. So business combinations with the idea of regulating business and not restraining it have been held to be desirable in public interest. If any regulation is made, beta please wait. I will take the queries at the last. So please wait. Till then you can send the query by on your portal. I will take. Business combination with idea of regulating business and not restraining it have been held to be desirable in public. अगर public के benefit के लिए regulation बन रहे हैं, they are welcome. An agreement between certain ICE manufacturing companies. See the example. An agreement between certain ICE manufacturing companies not to sell ICE below a stated price and to divide the profit in a certain proportion is not void. It means ICE manufacturing company has made a union and decided a minimum price to maintain the quality. It is perfectly valid. Such agreements are neither in restraint of trade or nor opposed to public policy, because the motive of this maintaining the minimum price is to maintain the quality. Service contracts, again important. Sometimes an employee, by the terms of his service agreement, is prevented from accepting any engagement during his employment. During, जब तक आप मेरे यहाँ नौकरी कर रहे हैं दूसरा काम नहीं करेंगे. A similar engagement after the termination of service, even after termination of service. First point is valid, first restriction is valid, second is not. First restriction, as regard the first restraint, it is valid and is not in restraint of trade if it is to operate while the employee is contractually bound to serve the employer. The doctor, for example, are usually debarred from private practices during the term of their employment. नॉर्मल केस में डॉक्टर से भी कहा जाता है जब तक आप सरकारी नौकरी कर रहे हैं हॉस्पिटल में आप अपनी प्राइवेट प्रैक्टिस नहीं करेंगे. So this type of restrictions are valid, but you will not do your own practice, own business even after the termination of service. Even after the termination of service is perfectly void. भैया अगर तुम नौकरी से निकाल दोगे और बेचारा बाद में काम भी नहीं करेगा तो फिर खाएगा कहां से, राइट? Agreement in restraint of legal proceeding, something like stifling prosecution. You can say that is the same provision. An agreement in restraint of legal proceeding is one by which one party thereto is restricted absolutely from enforcing his right under a contract through a court, or which abridges the usual period of starting legal proceedings. A contract of this nature is void. अगर कोई लीगल प्रोसीडिंग हो रही है आप उसको रोक रहे हैं करने से, उसका राइट को कम कर रहे हैं, these contracts are void, but certain exceptions. Please read section 28, then I will come to the exceptions. However, there are certain exceptions to the above rule. A contract by which the parties agree that any dispute between them in respect of any subject shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable is a valid contract. देखिए, if any in case of any dispute you have right to refer the court. If any agreement in which you are losing the right, you are waiving the right to refer the court is void. But if you are in this point, you are not leaving your right, you are just referring to arbitration. Now, what is arbitration? Actually, this is a full subject in your self-paced model. उसमें आपका सेट सी में ये है पेपर पूरा, but at this point only, I'm just taking the arbitration is like a panchayat. If there is dispute between A and B, and so A and B decide to refer the court, they may appoint a person like arbitrator, and he will work as a judge, any person. So both A and B will present their statements, their disputes, and Mr. Arbitrator will decide to solve the dispute. This is called ADR, alternate dispute resolutions. So law says if there is any clause in which a restriction regarding to refer the court because you can refer to arbitration is valid. A contract by which the parties agree that any dispute between them in respect of any subject shall be referred to arbitration, and the only the amount awarded in such arbitration shall be recoverable is valid contract. कि आप कोर्ट नहीं जाएंगे, आप अपना डिस्प्यूट आर्बिट्रेशन से सॉल्व करेंगे, this agreement is perfectly valid. Similarly, a contract by which the parties agree to refer the arbitration any question between them which has already arisen or which may arise in future is valid, but such a contract must be in writing. Listen once again. Similarly, a contract by which the parties agree to refer to arbitration any question, any dispute which has already arisen or which may arise in future is valid, but this agreement should be in writing. एक writing होना चाहिए कि भैया dispute होगा तो हम arbitration को refer करेंगे. One question from your side, Mr. Pawan Kumar, that CA can be arbitrator. Anyone can be arbitrator. Even I was the arbitrator in about 6 to 8 cases. 6 से 8 केस 6-7 केस थे जिसमें मैंने arbitrator role play किया है. I have decided the cases as arbitrator. Right? Please read it carefully. Saumil is asking, sir, suppose Tata company opened a firm named XYZ Limited by Tata company and sell the company to A, does in the name by Tata company remain the same? Depends upon the terms and condition. उनका क्वेश्चन ये है कि टाटा कंपनी ने एक नई कंपनी बनाई XYZ लिमिटेड बाय टाटा कंपनी और ये कंपनी बेच दी, तो क्या जो बायर है उस कंपनी का उस नाम को यूज कर सकता है? डिपेंड अपॉन द म्यूचुअल एग्रीमेंट. Right? Agreement, the meaning of which is uncertain. If meaning is uncertain, we have already discussed. There must be clear meaning. The agreement is void. Agreement, the meaning of which is not certain, is void. The uncertainty may be as to the existence, quality, quantity, price, title. See the example number 42, 43, 44. A agrees to sell to B 100 tons of oil. This example I have already discussed with you. There is nothing to show what kind of oil was intended. The agreement is void for uncertainty. याद है? Essential elements से पढ़ा था हमने ये. 43. A agrees to sell to B my white horse for rupees 5,000 or 8,000. Price is not certain. Again, it is void. A agreed to pay certain sum when he was able to pay. कि सर जब पैसा हो तो दे दूंगा. This is again void. Wagering, जुआ, सट्टेबाजी, betting. Please listen some points which are useful, which are important for your examination point of view on the wagering. Wagering agreement is void. Pehli thing, first thing, agreement is void. In case of state of Gujarat and Maharashtra, it is illegal. Any supporting collateral contract to the wagering is not void. Right? Now, what is wagering? A wager is an agreement between two parties by which one promises to pay money or money's worth on the happening of some uncertain event in the consideration of other parties promise to pay if event does not happen. क्या मतलब? I enter with Mr. X in a contract. I enter with Mr. X in a contract that I will give you rupees 100 if it rains on Monday. I will give you rupees 100 if it rains on Monday, and if no rain, you will give me 100. मैंने X से कांटेक्ट किया कि आप मुझे 100 रुपए दोगे अगर बारिश होती है, और अगर बारिश नहीं हुई तो दोबारा बोल रहा हूं, A and B enter into a contract. Let's see A and B. A asks B, I will give you rupees 100 if it rains on Monday, and if it does not rain on Monday, B will give you A rupees 100. A और B के बीच में कॉन्टेक्ट हुआ कि अगर मंडे को बारिश हुई तो A B को 100 रुपए देगा, और अगर नहीं हुई तो B A को 100 रुपए देगा. The event is uncertain. Both parties has chance to win. Whether any party has control over the event? Answer is no. So these are the essential elements for wagering, and these type of agreement are, if A and B enter into an agreement that A shall pay B rupees 100 if it rains on Monday, and that B shall pay A the same amount if it does not rain, it is wagering agreement. Right? Essentials of wagering agreement. Promise to pay money or money's worth. Performance must be dependent on the happening or non-happening of an event. Event must be uncertain. No control over the event by the no control of the parties over the event. Both parties has mutual chance to win or lose. कोई भी जीत सकता है, कोई भी हार सकता है. And no such other interest, no such interest in the event. This is wagering and void. But contract of insurance is not wagering because the company giving the insurance and the person taking the insurance have the same interest. मैंने इंश्योरेंस लिया किसी ABC कंपनी से कि सब मैं अगर मर जाऊंगा तो इतने पैसे मेरी फैमिली को मिलेंगे, तो ना तो मैं चाहता हूं मर जाऊं, ना मेरी कंपनी चाहती है मर जाए. They have the same interest. So that's why insurance is not a wagering agreement. It is contingent contract. Right? Effect of wagering agreement. Wagering agreements are void but not illegal. However, in case of Maharashtra and Gujarat, wagering agreements have been illegal. In only wagering agreement void in the whole India, but illegal in 2 states only, Maharashtra and, right? Please एक बार पढ़ लीजिए, because a direct question may be asked on the essentials of wagering agreement. पढ़ लीजिए बच्चों जरा एक बार. Suit to recover money deposited under wagering agreement. See the example. I have discussed the example A and B. A and B are under the agreement that A will pay the 100 rupees to B if it rain on Monday, and in consideration B will give rupees 100 to A if not rain on the Monday. अभी एग्जाम्पल डिस्कस किया हमने. A और B एक कॉन्ट्रैक्ट करते हैं कि अगर बारिश होती है मंडे को तो A 100 रुपए देगा और अगर नहीं होती है तो B 100 देगा A. अब दिस इज द वैगरिंग एग्रीमेंट because payment is dependent upon the happening or non-happening of an uncertain event. A problem is that A and B both agree that they both will deposit this 100 rupees to C because they don't have faith in each other. And with the promise with C, winner of this bet will give C rupees 10 as commission, as holding charges. A और B ने कॉन्ट्रैक्ट किया, दोनों को विश्वास नहीं एक दूसरे के ऊपर. दोनों का भैया 80, भैया तुम एक काम करो 100 मेरे से रख लो, ए ने कहा मेरे से रख लो, 100 बी से रख लो, और जो विनर होगा उससे सी 10 रुपए ले सकता है एज ए कमीशन, एज ए होल्डिंग चार्जेस. द कॉन्ट्रैक्ट ऑफ ए विद सी and B with C is perfectly valid because there is no wagering transaction in this type of contract. They are giving a holding charges, right? That winner of the bet will give the holding charges to C, right? Now what happened? Please listen carefully. A has won the bet. A has won the bet. Now A can recover only rupees 90 from C, not 190. Because the agreement between A and B is void. So A can recover his money only. But the agreement with C is perfectly valid. So A has to give rupees 10 to C. So A can recover only rupees 90 from C. But law says again, if C gives full 190 to A, if B gives 190 to A full amount, B has no right to recover the amount from C. He can recover rupees 100 from A. A ने वो बैट जीत ली. A कितना रिकवर कर सकता है? C से 90 रुपए, क्योंकि 100 वाला कॉन्ट्रैक्ट तो वाइड था, तो उसने 100 रुपए दिए थे, 10 वाला कॉन्ट्रैक्ट वैलिड था, तो 10 रुपए काट के वो रिसीव कर सकता है और B C से अपने 100 रुपए वापस ले सकता है. लेकिन अगर C ने पूरे 190 रुपए A को दे दिए तो B का जो राइट है 100 रुपए वापस लेने का, दैट विल बी अगेंस्ट B, अगेंस्ट A, नॉट C. अगर गलती से C ने पूरे पैसे दे दिए A को तो B A से रिकवर करेगा 100 रुपए अपने, ना कि C से. So money deposited with a person called stakeholder to be paid to the party winning upon a wager cannot be recovered by the winner. On the other hand, the loser can recover his deposit from the stakeholder. But where the stakeholder pays the money to the winner, the loser cannot recover it from him. These are collateral transactions supporting. The validity of collateral transaction cannot be challenged because the main object, the main contract, which is wager and void. Example, in a wagering contract, the broker is entitled to collect the. Clear? Please read it. एक बच्चे ने पूछा है, सर वाई इलीगल इन महाराष्ट्र एंड गुजरात? तो आई डोंट हैव द रीजन. मेरे पास रीजन नहीं है, तो गवर्नमेंट का अपना प्रोसीजर है. सेकंड, सर इफ C is contract with A and B is collateral. C contract between A and C and B and C is collateral transaction, right? सौमिल का पॉइंट है सर 8 पॉइंट रिपीट कर दो, अभी देखते हैं बेटा. लेट्स सी. Exception: following transactions are not wager. Game of skill, crossword puzzle, picture puzzle, athletic competitions are not wagering. They are valid. A subscription or contribution of an agreement to subscribe or contribute towards any plate or cup in a race, prize or sum of money, the value of rupees 500 or above to the awarded to the winner or winners of the horse race. आप horse race में पैसा लगा रहे हैं जैसे सट्टेबाजी, लेकिन you are awarding the winner of the horse race is allowed. Share market transactions are perfectly valid. They are not wagering. Insurance contract is not wagering. It is contingent contract. Agreement to do impossible act. If any agreement to do some impossible act is always void. Point number 8. I have discussed beta if any agreement in restraint of legal proceeding is perfectly void, but if it is just restriction as per the agreement for the legal proceeding to refer the court, in place of that you may refer arbitration, it is perfectly valid, right? So आते हैं आगे लास्ट पॉइंट सुपर ओवर 4. इसके बाद में आपकी जो क्वेरी है वो ले सकता हूं. Soumya says, sir, if A can give 100 rupees to B, then B can sue case. Then एक मिनट से A can't give rupees 100 to B. A can't give. A is the winner, and A can recover only rupees 90 because he has given 100 rupees to C, and C has the right to recover 10 rupees from A. So A can recover only 90 and B has the right to recover his 100 rupees from C. If C has given all the money to A, so B has right to recover against the A, not for B, right? So start करते हैं बच्चों, क्योंकि टाइम हो रहा है, आपकी नेक्स्ट क्लास भी है, क्वेरीज भी डिस्कस करनी है. Come to the super over 4. All agreements are contract. Please listen carefully. ध्यान देना बच्चों, जल्दबाजी नहीं करना है. All agreements are contract only if they are made for lawful consideration and with lawful object. It is given in section 10(23), both A and B, none of these. A, B, C entered into a contract to carry on some fraudulent business and to share the profit in equal share. This agreement is valid, void, voidable, contingent. An agreement which prevents a person from marrying a particular person or a person of the particular class is valid, void, voidable, allowed with court's permission. An outgoing retiring partner can be restrained from carrying on the similar business only. Any business, both of these, none of these. Regulation as to the opening and closing of the business in the market are not legal. Valid, void, illegal. A agrees to enclose a space between two parallel lines. Enclose the space between two parallel lines, and B agrees to pay rupees 5,000 to A for this act. This is an agreement to do illegal act, impossible act, wagering act, forbidden act. So please send the answers. Waiting for 1 minute. This is a tricky question because these words are given in section 10. Because section 23 provides what are the unlawful object and consideration. This line is mentioned in section 10, जिसने first lecture लिया होगा से clear होगा. Fraudulent business, void. Restriction in marriage, void. Similar business only. Regulation as the opening and closing of business in the market are valid. This is an impossible act. Let's see. First one who has given the correct answer is Kaushal. Mr. Praveen Kumar, congratulations both of you. बस यही आया आंसर अभी मेरे पास. So this was the unit number 3. And again I'm saying beta ki please get revision of this unit number 3 so that in the next class we will able to get 10 on 10 in self-assessment test, right? So any query from your side, please, I am waiting. If there's any query, Amit. Sir, kindly allow Amit. Sir, unmute कर दीजिए अमित जी को. Sir, technical support, can you hear me, sir? आप सुन. Sir, please allow करिए बच्चों को.
सर गुड आफ्टरनून.
गुड आफ्टरनून बच्चे.
सर मेरा क्वेश्चन एग्जांपल नंबर 21 में था सर.
Example number 21. Give me
29 सर.
29.
जी सर.
Just a moment. Example number 29. I'm going for that. Yes, ask. Example that I ask B, if you arrange a girl for me with girl for marriage with me, I will give you 50,000. Right?
हाँ जी सर. जी सर.
अगर आप पैसा देके कोई लड़की दे रहे हैं शादी के लिए, this is the illegal act in our
इमोरल. यस सर, इमोरल माना जाएगा ना.
immoral and bad and immoral, that's why it is illegal. And
नहीं
bad.
सर, फिर ये जो शादी.com ऐप है ना, ये
Sir, they
इमोरल
are
काम कर रहे हैं.
Sir, they are not providing a girl or boy for money. They are just making the consultancy. वो आपको क्या कर रहे हैं कि आपसे कंसल्टेंसी फीस ले रहे हैं और जो लड़का या लड़की पर रजिस्ट्रेशन करा रहे हैं उनकी कुंडली मैच करा रहे हैं. आप आपस में बात कर लो, हम अरेंज नहीं कर रहे हैं.
अच्छा.
आप चेक कर लो. राइट.
हाँ जी. हाँ जी.
ठीक है, क्लियर हुआ.
जी सर.
ओके, नेक्स्ट वन.
কি বলে স্যার বুঝিস? আচ্ছা আচ্ছা.
Anyone? Anyone else? प्लीज अनम्यूट कीजिए अपने आप को जो क्वेरी है जिनकी. आई थिंक कोई अनम्यूट नहीं कर रहा है. कोई हो प्लीज, क्वेरी हो तो प्लीज पूछिए बच्चों. मेगा मैम, आर यू देयर सर मैम?
Yes, sir. Sir, I'm just checking. Because
अच्छा,
I have just given them the option of unmuting, but they are not speaking.
ठीक है. तो मैम, शुड वी क्लोज द क्लास?
Sir,
Yes,
can I
yes.
ask a question?
अच्छा, one person is there. Yes, please ask.
Very good afternoon, sir.
afternoon.
Just can you please give me a short brief again regarding the wagering agreement, sir?
Wagering agreement just like a betting agreement, in which the transaction, not transaction, you can say the payment is dependent upon the
Dependent on a
event,
situation, sir.
upon
Hello.
upon uncertain event. So that is just like a betting, शर्त लगाने के contract. In this case, the contract are void.
Okay, sir. Thank you.
Okay.
सर 6th 1 एक बार आप अच्छे से समझा सकते हैं? 6th 1
Sixth
सुपर
one,
ओवर
which is
4
super over 4. Let's see.
जी 6th 1
And agree to enclose a space between two parallel lines. दो parallel line है ना जिनमें space बराबर होता है. अब क्या वो स्पेस खत्म किया जा सकता है? अगर वो खत्म हो जाएगा तो पैरेलल लाइन ही नहीं होंगी वो. तो या तो स्पेस हो सेम होगा या नहीं, तो पैरेलल लाइन नहीं होंगी. इसलिए दिस इज द इम्पॉसिबल एक्ट, राइट? क्लियर हुआ बच्चे?
सर
जी.
सर मैंने आपकी टीचिंग से पहले भी इंडियन कॉन्ट्रैक्ट कंप्लीट कर लिया था.
ठीक है, बहुत अच्छी बात है बेटा.
ये रिवीजन ये अपनी बैच चालू होने से पहले.
जी.
लेकिन मुझे कंटेंट तो सारे मुझे कॉन्सेप्ट तो मेरे क्लियर है, लेकिन मैं अभी भी जब
बेटा आवाज रुक गई, दोबारा बोलिए. किसी बच्चे की डांट लग रही है घर पे. बेटा कोई प्रिंस रह गई आपकी क्वेरी बीच में, बेटा प्लीज पूछिए. नहीं है मैम, लगता है आवाज चली गई, शायद कुछ दिक्कत हो गई है.
यस सर.
ठीक है मैम, तो क्लोज करें मैम फिर.
यस सर, क्लोज
ठीक है
कर
मैम.
देते हैं.
थैंक यू सो मच बच्चों. थैंक यू फॉर
Recording
पेशेंट
stopped.
हियरिंग. थैंक यू. थैंक यू मैम.